Employer-sponsored health insurance, or ESI, is, well, a cornerstone of health coverage for most working Americans. However, this type of insurance is typically tied to active employment status. This creates a vulnerable scenario. If an employee becomes seriously ill or injured and can no longer work, they not only face health challenges, but also the potential loss of their health insurance. This report evaluates the ethical and legal responsibilities of employers in informing employees about these implications. It examines the consequences of losing ESI due to illness, the stopgap of COBRA continuation coverage, which includes its high cost, 18-month limit, and lack of long-term continuity. It also highlights the true cost of ESI, noting that employees effectively pay the full premium through reduced wages, while employers benefit from tax breaks. To illustrate how widespread this issue is, we compare ESI premium and out-of-pocket cost data across different public institutions, highlighting extreme cases like Sioux City, Iowa, and contrasting examples from Aurora, Colorado, and Nebraska. Finally, we analyze the fiduciary duty of employers in this context, assessing how accountable they are, ethically and legally, for failing to disclose that employer-sponsored insurance may not provide continuous protection if an employee falls gravely ill. Under a typical ESI plan, coverage is contingent on the individual's employment. If an employee is unable to work for an extended period due to illness, their job and thus their insurance is at risk. The Family and Medical Leave Act, or FMLA, offers some short-term protection. Eligible employees can take up to 12 weeks of unpaid leave with continued group health coverage under the same conditions as if they were still working. In practice, this means the employer must continue the health insurance during the FMLA leave, although the employee is usually responsible for their normal premium share. FMLA provides job protection only for those 12 weeks. If the employee cannot return to work after that period, or if the employer is not covered by FMLA, the employer may terminate their employment, causing the loss of health benefits. At the point employment and regular coverage ends, COBRA, or the Consolidated Omnibus Budget Reconciliation Act, becomes critical. COBRA is a federal law that allows many employees to continue their employer's health plan for a limited time after leaving employment. However, this continuation comes with important caveats. First, COBRA coverage generally lasts up to 18 months for the employee and their covered dependents after a loss of job-based coverage. Certain qualifying events can extend COBRA for dependents to 36 months, and in cases of the employee's disability, an extension to 29 months is possible. Second, the entire premium cost is now borne by the individual. The law allows the plan to charge 102% of the premium, with the extra 2% covering administrative fees. If a disability extension applies in months 19 through 29, the premium can rise to 150% of the plan's cost. In other words, the employee must pay both their share and the former employer's share of the premium, plus a surcharge. This often represents a substantial increase. What was once partially subsidized through the employer is now fully out of pocket. Lastly, COBRA is, by design, temporary. When the 18-month or 29-month period ends, coverage terminates regardless of whether the individual is still willing to pay. There is no legal requirement for further extension. Even if the person is still in active treatment for an illness, they must transition off the employer plan, for example, by finding an individual policy on the marketplace, or, if eligible by then, transitioning to Medicare or Medicaid. There is no guarantee of keeping the same providers or coverage terms after COBRA ends, which can disrupt continuity of care. The consequences of these rules for a seriously ill employee are frankly severe. First, the sudden need to pay the full COBRA premium is often a shock. To put this in perspective, the average annual premium for a family ESI plan in the United States is now around $23,000, roughly $1,900 per month. This cost, which is usually shared between employer and employee under COBRA, falls entirely on the individual at a time when they have likely lost their income. Many employees facing illness may be on disability leave or have no income, making the COBRA premiums, which can easily exceed $1,500 to $2,000 per month for family coverage, unaffordable. Second, even for those who can afford COBRA, after 18 months, the safety net vanishes. For example, an employee undergoing lengthy cancer treatment could find that a year and a half into treatment, their COBRA coverage expires, leaving them to find new insurance, potentially with different coverage networks or drug formularies, in the middle of their health crisis. This lack of continuity can interrupt care and add stress for someone already in a dire situation. In summary, becoming too sick to work often means losing ESI at the worst possible time. Employers who offer health benefits must navigate the legal requirements of notification and continuation, but the system's design still leaves a gap that employees may not be prepared for. It's important to recognize that employees effectively pay the full cost of their insurance one way or another. While employers might seem to cover a portion of health premiums, economists generally agree that this cost ultimately comes out of total employee compensation. In simpler terms, money spent on benefits is money that doesn't appear in wages. If employers didn't provide health insurance, they'd likely have to offer higher salaries to attract workers in a competitive market. So from this perspective, employees are essentially paying for their health insurance through reduced take-home pay. A clear sign of this is how steadily premiums rise compared to wages. Between 2018 and 2022, public school employees' health premium contributions rose by about 14%, outpacing salary increases of around 10%. For instance, the average teacher's monthly premium contribution for family coverage increased from roughly $592 in 2018 to $711 in 2023. These rising benefit costs often suppress wage growth, meaning workers trade potential raises to maintain their insurance coverage. So even though the employer is the one writing the check to the insurance company, the employee bears the cost in the form of reduced cash compensation. Now, employers and employees do receive significant tax advantages for employer-sponsored insurance. Employer contributions for health insurance are tax-deductible for the company and excluded from employees' taxable income. Neither party pays payroll or income taxes on the value of employer-paid health premiums. This tax exclusion is a massive federal subsidy. In 2022, it cost the U.S. government an estimated $299 billion in lost income and payroll taxes. That makes it the single largest tax break in the federal budget. Essentially, the government sacrifices tax revenue to encourage employers to provide insurance. Employers benefit by compensating employees with untaxed benefits instead of taxable wages. Employees also save on taxes for the portion of premiums the employer pays, and even their own share is often paid with pre-tax dollars. However, this arrangement can obscure the true cost of insurance from the employee's perspective. Many don't realize their plan might cost, say, $20,000 a year in total because they only see a few $100s deducted from their paycheck, not the portion the employer pays. The full cost becomes painfully clear when an employee has to pay the entire premium under COBRA, or when they realize those invisible employer payments were always part of their compensation package. It's a sobering reality. The burden of employer-sponsored insurance premiums on employees varies widely across different employers. Public institutions like school districts provide a striking example of how costs can differ. Take Sioux City Community School District in Iowa, for instance. Starting in 2024, a Sioux City teacher must pay about $2,258 per month to add a spouse and one child to the district's family coverage plan. That's over $27,000 a year out of pocket for the teacher. Taxpayers contribute an additional $10,827 annually, bringing the total family plan premium to nearly $38,000 a year. In this case, the employee is covering about 71% of the cost, an extraordinarily high burden. For context, the national average for teachers' family premium contributions is around $711 per month, so Sioux City's costs are more than 3 times that amount. Such expenses might even discourage teachers from electing family coverage, leaving spouses or children to seek insurance elsewhere. Meanwhile, in Aurora Public Schools in Colorado, the district contributes a set amount toward premiums, and employees pay the rest. For a family plan, this often leaves employees paying anywhere from $700 to over $1,000 a month. While significant, Aurora's costs are closer to national norms, with the district covering about half the family premium. Then there's Nebraska, where many K-12 public schools pool resources through the Educators Health Alliance. This statewide collaboration often results in employers covering 80 to 100% of premiums, especially if employees meet wellness criteria. In one district, a family plan premium of about $1,800 per month could cost the employee as little as $0 if wellness incentives are met. These examples highlight a patchwork of affordability across the nation. In some places, employees face crushing costs, while in others, employer contributions significantly ease the burden. But in every case, the full cost of insurance becomes starkly apparent if the employee must pay the entire premium under COBRA. Do employers have an ethical or legal obligation to inform employees that their insurance might not provide continuous protection if they fall seriously ill? This question touches on both legal fiduciary duties and broader ethical principles. Legally, private sector health plans are governed by the Employee Retirement Income Security Act, or ERISA, which requires plan administrators to act in the interest of participants. This includes being truthful and providing clear information about coverage terms. Employers must also provide summary plan descriptions that outline eligibility and termination conditions and notify employees of their COBRA rights when coverage ends. However, beyond meeting these legal requirements, the question of broader fiduciary duty is interesting. Courts have ruled that employers must not mislead participants and they must answer questions truthfully. For example, in the Supreme Court case Verity Corp v. Howe, an employer was held liable for misrepresenting the security of employee benefits. The takeaway? Employers have a duty of honesty and completeness when conveying benefits information. Ethically, though, the situation is more complex. While legal standards focus on required disclosures, many argue that employers owe their employees clarity about the limitations of their benefits. Health insurance isn't just another perk. It's something employees rely on for their well-being. Employers who fail to communicate the fragility of coverage may leave employees unprepared for worst-case scenarios. Some employers go further, including detailed explanations in handbooks or orientation sessions. For instance, they might explain that health coverage continues during paid leave or FMLA, but ends if employment is terminated, with COBRA as an option. This kind of transparency respects employees' right to understand the risks they face. Unfortunately, many workplaces don't provide this level of communication. The result? Employees often feel blindsided when they lose coverage during a health crisis, even if the employer technically followed the rules. Ethically, bridging this gap is about more than compliance. It's about respecting employees as informed partners in the employment relationship. Employer-sponsored insurance is in many ways a double-edged sword. It's a vital benefit while one is employed, but it can fail precisely when an employee's health crisis makes continued employment impossible. COBRA provides a safety valve, but its high cost and time limit make it a temporary and expensive solution. Employees effectively pay for their insurance through their work, while employers benefit from significant tax incentives. Yet, when an employee's health takes a downturn, the protection they've relied on can vanish. The examples of Sioux City, Aurora, Nebraska, and others show the wide range of burdens employees face. In some places, the costs are crushing even for healthy workers. In others, employer contributions ease the burden, but the loss of that support during extended leave can still be devastating. Legally, employers operate within a framework that doesn't require them to guarantee coverage continuity beyond employment. Ethically, however, the situation is troubling. Employees deserve to understand the limitations of their insurance and the risks they face. Employers should strive to communicate these realities clearly and compassionately. By doing so, they respect their employees as informed partners and uphold values of loyalty and care. In the end, empowering employees with knowledge is not just good ethics, it's good practice.